Introductions by members. Madam Clerk.
Introduction of bills. Orders of the day.
Government House Leader.
Thank you so much, Honourable Speaker. In the main chamber, called Committee of the Whole on Bill 10, Commercial Transportation Amendment Act. Douglas for a committee room called Committee of Supply for the Ministry of Forestry, and after that completes, call the Committee of Supply for Ministry of Emergency Management and Climate Readiness. In the Birch Committee room, we call a Committee of Supply for the Ministry of Environment and Climate Change Strategies.
Committee chairs.
Right, members, if the Minister and the critic are ready, I believe we are on Clause 2. So we'll get started with Bill 10, Commercial Transport Amendment Act 2024. Member for Surrey White Rock.
Thank you and welcome, Mr. Chair. We're talking about Clause 2, Section 12. Seen here, not more than 500, not more than 100,000, or to imprisonment for not more than 18 months or to both. So when we're talking about the Commercial Transportation Amendment Act, has anybody ever been imprisoned under the Commercial Transportation Act?
the Minister of Transportation and Infrastructure.
Thank you very much, Mr. Chair. Let me begin by doing something I neglected to do at the outset of committee stage, and that is to introduce the staff at the Ministry of Transportation and Infrastructure who are assisting us during this debate. To my left is Steve Haywood, who's the Executive Director and Registrar for the Commercial Vehicle Safety Enforcement Branch, and to my right is Kirk Rockerby, who's the Manager of Transportation Policy, and behind me is Jackie McMorrin, who's our Legal Counsel. And this morning, Jeremy Wood was here, and he's our Executive Director of Strategic Policy and Legislation. So the member asks about the Commercial Transport Act and whether there are any sections that allow for imprisonment, if I heard him correctly. And there is only one section that has a reference to this, and it's section 7.02. And that is a provision that outlines the violation of permit conditions. And to our knowledge, no one has ever been charged or convicted to serve a term of imprisonment for a violation of section 7.02.
Member.
Apologies to the Minister. So I did not hear that clearly, and that was my fault. So I asked if anybody has been imprisoned resulting from the Commercial Transportation Amendment Act in this province.
Minister.
Repeat for the member that there is one section that does contain provisions around a sentencing that could include a term of imprisonment. It's section 7.02, and it's around violation of permit conditions. And to our knowledge, nobody has been charged or prosecuted that led to a term of imprisonment.
Member.
Thank you, Mr. Chair, and thanks to the Minister for that answer. So again, going back to the 18 months, can the Minister give an example of what may have to transpire for somebody to receive the maximum sentence that's going to be in this legislation of 18 months?
Minister.
Thank you, Honourable Chair. The Crown Counsel, of course, would likely, in a scenario that we're imagining here this afternoon, where you had a very egregious offence, the circumstances were such that Crown Counsel pursued charges, and the circumstances of the investigation by police and other agencies warranted and met that two-step test, both likelihood of conviction and conviction being in the public interest. In the course of a trial, Crown would obviously make submissions on sentencing, and when there's a finding of guilt, within that trial, and then that allows a judge to determine a range of penalties, both financial and potentially imprisonment or both.
Member.
Thank you, Mr. Chair. So the minister just brought up a good point here. So when we're talking about the $100,000 and how that could be levied, so let's take we know who's going to decide whether or not the court will decide about imprisonment, get that part of it. In terms of the monetary fines that could be levied, who will be making that? Did the minister say a court would be making that decision? Would the ministry be making that decision? Would cabinet be making that decision, or is that going to be left in the hands of the judicial court?
Minister.
So that will be determined at trial and then ultimately by our independent judiciary. So it'll be up to a judge. Right now, maybe to explain what we're gaining here by passing this legislation is right now there is no ability to do that under the Commercial Transport Act. There will be upon royal assent to this bill, and it will allow, again, a range of sentencing options for a now prosecutable offense where there isn't one today.
Member.
So the maximum fine as of right now is $500. I believe that to be correct. So who makes that determination if the driver is going to be fined $500?
Minister.
But there's a maximum, right? Yeah, okay. So right now, the $500 fine maximum that exists, that's for a violation ticket at roadside that could be issued by police or the Commercial Vehicle Safety Enforcement Unit. This legislation will actually allow us to increase those fines, but the much more serious sanctions that are under discussion in this section of the bill relate to a different process that is adjudicated in court.
Member.
Thank you, Mr. Chair. So what is that threshold then? Is it $1,000? Is it $5,000, $50,000, $75,000, $100,000? So when does that kick in? So you get stopped, you're oversized, or you've struck something. Who's making that determination whether CVSE can issue a fine, whether you have to go to court as an escalator? Is there a certain threshold that needs to be met? Can the minister clarify that?
Minister.
So the authorities that would attend an accident could immediately issue a VT with that fine. But upon a police investigation, and again we're talking about what would likely be a very serious accident, or based on facts found out about the driver and their previous record of infractions, there'd be a whole bunch of circumstances that would be determined as fact during the course of the investigation that would inform Crown Counsel, that would then take it to court, and then the discretion on the, as he would call it, the threshold, the ultimate penalty amount would be determined by a judge, not by the ministry or cabinet or any other process. But legislation will allow a judge to go as high as $100,000.
Member.
Thank you, Mr. Chair. So again, to the minister, so the truck gets stopped, it's over height. So does CVSE have the ability to issue a fine? To what extent? Can that fine be $500? Can it be $100,000? If there is a strike that happens at an overpass, CVSE attends, can they issue a fine that can be $500,000, $50,000, or $100,000? Or is that responsibility for the entirety, whether it's 500 or 50 or 100,000, is that responsibility now solely in the hands of the court?
Minister.
Thank you very much. So the attending officer will basically have a choice based on what they're seeing at the scene of an incident, of a serious collision, let's say. And will have the choice between an enforcement order issued then and there, or whether they wish to, after the adoption of Bill 10, now pursue a long-form information process, which would provide charging recommendations to Crown Council, which would seek a much higher amount that will be available under the CTA.
Member.
Thank you, Mr. Chair. The amendments under Clause 2 amend Section 12 of the Commercial Transportation Act, and it references a person, quotation marks, a person who contravenes. Can the minister clarify, does person mean the driver, or can it also mean a company and/or personnel within that company?
Minister.
So to the member, it's important to note that there's no changes to whom the CTA offense applies to. Mostly the person is the driver, but owners can also be held liable, and I'll return to that in a second. Of course, there's a not insignificant portion of the industry that are owner-operators, where they are one and the same. A ticket issued to a driver, though, also flows through to the carrier's national safety certificate. So the accumulation of citations on their safety certificate is held in record, and the carrier's liability for being part of the unsafe behavior that has caused the incident can then become, often based on an accumulation of safety citations, can then be part of the progressive enforcement system that we described earlier in this debate, where they can have suspensions of their entire fleet and therefore be involved and be held liable for the incident that set that in motion.
Member.
Thank you, Mr. Chair. So just to be clear, if an overpass is struck, significant damage, there's negligence. Two questions. One is you could find the operator of the vehicle, the driver, may not have the means to pay the maximum penalty, and then could an operator face imprisonment time as well? So based on the explanation just given there, could an operator face imprisonment based on these legislative changes, even if they're not operating the vehicle that struck an overpass?
Minister.
Thank you. So this is similar to the last answer. The amendment here assigns the fine and would pursue it through a conviction in a court, and it would be an individual, so it would be the driver. As I've said, in many cases the driver is the owner, and there are other sections of the Motor Vehicle Act, and there is the progressive enforcement regime that deals with the carrier where they're a contributing factor to negligence that's part of the accident.
Shall Clause 2 pass? So ordered. Shall Clause 3 pass? So ordered. Shall the title pass? So ordered. Minister.
Mr. Chair, I move that the committee report the bill complete without amendment.
Members have heard the question. All those in favor? Opposed? Carried. Thank you, members. This committee is adjourned.
Committee Chair.
Thank you, Honourable Speaker. Committee of the Whole for Bill 10 reports the bill complete without amendment.
When shall the bill be read a third time, Minister?
Now, Mr. Speaker?
Members, the question is the third reading of Bill 10, Commercial Transport Amendment Act 2024. All those in favor say aye. Aye. Opposed? Motion carried. Bill 10, Commercial Transport Amendment Act 2024 has been read a third time and has passed. Government House Leader.
Thank you very much, Mr. Speaker. I'm wondering if we could take a small pause. We're going to move on to miscellaneous stats bill, and I know we're waiting for the relevant minister to come, and it should be just a number of minutes, and we'll get
The
started.
House will end a short recess. Thank you.
Okay, members, let's call this legislature back to session. I acknowledge the acting government House Leader.
Thank you very much, Mr. Speaker, and apologies to the delay. It couldn't be avoided. I'd like to introduce, for Committee of the Whole, Bill 9, Miscellaneous Statutes Amendment Act 2024 for debate.
Thank you, Minister. We will move into committee. Would the attorney like to start with an opening statement? Attorney General.
Hi, thanks, Chair. I would just like to introduce my team and thank them for all their work. We have Anita Najeko, Director of Policy and Legislation, Taryn McKenzie, Senior Policy Analyst, and Dotan Amit, Policy Analyst. Thanks.
All right, Bill 9 on Clause 1. Member for Abbotsford West.
Thanks, Honourable Chair. And just when we thought our opportunities for these delightful exchanges might have ended, here we are yet again. We'll get right to it. Clause 1, I take it, is designed to address a problem or an issue that has cropped up with respect to the Lobbyist Transparency Act. I'll ask the first two questions in this order. What is that issue or problem that has given rise to this amendment?
Attorney General.
So this was just, I guess it wouldn't be to fix a problem, it was just to maybe amend itself to the nature of how the online system worked. So by removing prescribed form and manner and replacing it by manner specified from the registrar, it allows a registrar to update and change the form online.
Member.
Thanks, Honourable Chair. So then maybe the question that follows from that is, is there a concern around the level of certainty? And I have the minister's, the attorney's point about changing online forms, but if that is the case, presumably the term prescribed form would allow for the registrar to make that change at any time in any way that they would choose. A prescribed form available online can be changed at any point. So I'm not certain I follow the distinction.
Minister.
Okay, so by the term prescribed, it requires a regulation. And what's happened in practice is there's never been a regulation on this because it's up to the independent officer through the online process to do it in the form and manner that they see fit. So it really is just a clarification of that.
Member.
Thanks. So there, with respect to Section 3's Sub 1 and Sub 3, there isn't today a prescribed form?
Minister.
No.
And that is presumably is intended to be changed following the passage of this section?
Attorney.
There wouldn't be regulation because the power to make regulation for this has been removed through this amendment, and it just basically reflects the status quo of what's happening right now, which is that the registrar as an independent officer sets the form and manner of it.
Member.
Thanks, Honourable Chair. I don't want to over-dramatize this, although I suppose some within this carefully regulated business of lobbying might. I won't. But if what the Attorney General is saying is correct, and the forms that have been used are the result of the work of the registrar, but have not been prescribed in the way that the present section requires, then are those forms actually valid today?
Attorney.
Yeah, just to bring clarity to what we're talking about here is it's not an actual form, it's a registry. So it sets out that basically the status quo, which is that the registrar is responsible for the form and manner of that registration, and that occurs online. So it's within the purview of the independent officer with the online resources. You just make sure that that's clear.
Member.
Thanks, Honourable Chair. So I'm just going to bring up the section on my hard drive here. So there's no concern that there is apparently today under 3 sub 1 and 3 sub 3 3 sub 1 requiring that a lobbyist must file with the registrar a registration return in the prescribed form. So that's, I think that's what we're dealing with, something that within 10 days after beginning to lobby on behalf of a client, a consultant lobbyist must file with the registrar a registration return in the prescribed form. That suggests to me filing a document. Am I reading that correct?
Attorney.
So when we look at the Act on a whole, it does in the Act talk about what types of information, which I think the member's getting at, is required to be registered. This is simply talking about form and manner, so not an actual form, just that in practice it's an online registry and people register online. So it isn't about, there's other things that might talk about the content or the what must be filed, but this is just a simple thing to say it's in the form and manner prescribed by the registrar, so the online registry can be maintained by them without need for prescribed forms or any kind of regulation, which wasn't happening anyway.
Member.
All right, thank you, Honorable Chair. I mean, it's interesting to the extent that what we may be dealing with is the transition between a paper-based system and an online system. Was there ever a form? I think my point is, when this act was created, my guess is that there was actually a form, and that we have evolved out of that into an online system. Am I describing that correctly?
Attorney.
Yeah, so I'm told it's been online for quite a while, and certainly since 2020 when the major changes were made. But the member may be right that this is my maybe legacy language, but it does reflect the current state of these amendments, and just better reflect what's happening, which is with the online registry that's managed by the registrar.
Member.
Thanks, Honorable Chair. Is there any concern whatsoever within the ministry that is generally concerned about these, that the evolution in the technology is only now being matched by the evolution in the law, and that exposes the registry and the ministry to a suggestion or allegation that the present state of the registry falls outside of the present, until this passes, let us say, the present ambit of the law. Is there any concern whatsoever that the law simply hasn't kept up with the evolution of the technology?
Minister.
Thank you. No concern at all. This is really very much a minor amendment to reflect how the registry's been operating online for a long period of time. And as I mentioned before, the important thing is that the Act on a whole mentions what type of information must be in there to comply with that, with the Act. So that's the important part of that. This is relatively benign.
Member.
And then I think the final question relating to this issue, the other thing that occurred to me when we shift from a prescribed form, meaning a regulation, as the attorney has pointed out, to transferring authority to the registrar, the good news is changes can be made more easily and don't require the OIC. The bad news can be for the people who are utilizing the service, is it changes very quickly and all the time, and they are confronted each time they are obliged to register with a different set of requirements. What assurance can the attorney, with the assistance of her staff, provide that those who are obliged to provide this information aren't either going to be confronted by an ever-changing series of requirements, or an ever-changing series of requirements?
Attorney.
So the registrar is mindful of that, and I know through the operation of the independent registry that they have staff on board to actually explain changes if they're made to people. And I've been told that, you know, from various groups, they call up and they get answers right away. They also have the ability to, if changes are made, which I think, you know, happen from time to time, they also have the ability, and they put time into educating people about those changes. But generally speaking, I think we haven't heard concerns about that.
Member.
And the requirements will be, it's a question through you, Honourable Chair, will be uniform and not dependent, again, this is a question, not dependent on which officer within the office I happen to be speaking with. That is to say, there will be a single registry requirement, and it won't be open to interpretation of various assisting officers, because that can also be frustrating, as the attorney, I'm sure, will agree, if the advice or requirements one receives are different depending on who you talk to.
Minister.
Thank you. I can assure the member that we haven't heard that kind of concern with the services that the registry provides the public.
Member.
And just with respect to this clause, I don't think it does, but can the minister confirm, does this change in any way the substantive requirement to file a registration for either a lobbyist, a client, or a consultant lobbyist?
Minister.
No.
Shall Clause 1 pass? Aye. So ordered. Shall Clause 2 pass? Recognizing the member for Abbotsford West.
Thanks, Honourable Chair. Well, let's just start again where I started with Clause 1. Problem or issue that the changes proposed in Clause 2 are designed to address.
Minister.
So this particular amendment, I think you're asking about the whole section, so I'll maybe go through that. So there's two things that the amendments in H and I guess I that are removed, they do. So the first one is to clear confusion that was happening on the ground with respect to coalition. because coalition can be confusing in the sense where it could be a separately registered organization that uses the term coalition because it is a coalition, but it's actually registered as a nonprofit or other organization, and that's lobbying. Or it could be a coalition in another sense of just organizations that are separately registered coming together to lobby. And we found that the use of the word coalition was causing confusion because of those two interpretations of it. So instead, it was amended to describe the activity. So the activity of lobbying, lobbyists working together with another lobbyist. So it's in a sense forming the latter version of coalition that I described, but it's describing that activity and outlining that they need to register. This was something that people were telling us was causing confusion in what was needed to register and who was needed to register and how. So that was the reason for that. The second change was specifically to remedy an issue that particularly nonprofit organizations were coming us to say, which they often do request government funding. So it's changing it from registering every time you request funding to when you receive it. So you can see that one section is removed, and it's just really to get at the administrative burden that was putting on organizations that sometimes when you're requesting often for government funding, you're only successful sometimes, so it's just reducing that administrative burden on registering.
Member.
Thanks, that's helpful, Madam Chair. Let's deal just with the first part of the section. The description, so the abstract description that the attorney has provided is helpful. But is there an actual example? I'll tell the attorney through you, Honourable Chair, where I'm going. My impression is that by making this change, the number of organizations captured by the section should actually be reduced as opposed to expanded, because the rationale seems to be that the existing use of the term coalition was causing confusion that led organizations that weren't captured by this to think they were. So if this is designed to address that confusion, the scope of the number of organizations captured should be reduced. But it would be helpful to have a real life example of where this cropped up.
recognizing the Minister for Post-Secondary Education and Future Skills.
Thank you, Chair. I seek leave to make an introduction.
Members, is leave granted?
Thank you, Chair. So up in the gallery joining us today right now are the work-able graduate interns in our building, and very happy to have you all. These are internships across the BC Public Service for recent post-secondary graduates self-identifying as having a disability. They're 12-month internships, and they run all across BC from September to September, and they encourage people with disabilities to consider a career in BC's public service. And so I want to make you feel very welcome, and I hope the House will join me in welcoming you to the Legislature. Thank you.
Minister.
So these changes to the provision don't change the reporting requirements. They seek to bring clarity. So let me talk through it by example. So we can think of an organization, so I'm just going to give a hypothetical. So if I'm an organization that the name of my organization is coalition or am a coalition, but I've separately set myself up with the board of directors, registered myself, like I'm a separate organization or I act as one, then that's different than what we're changing here, which is that if you are a coalition in the sense of a whole bunch of individual organizations that have come together to meet with an MLA, for example, right? Then it's clarifying that in one case, you can register the former one, you can register just individually that organization without listing the organizations that attended. But if you are the other version of the coalition that I described, where you're a bunch of organizations separately registered, separate organizations coming together to lobby, that the list, the names and businesses of the organizations are part of what needs to be registered. And what we were finding was that there was confusion in that. So in that sense, we might actually have less reporting, because if you're a coalition that's formally organized as a coalition, as an organization, you may have before gone through and said, oh, do I have to list every single one of the organizations that form my formal structure, that sit on the board or whatever, and that was not necessary. So it clears up that confusion and would reduce the administrative burden on that side.
Member.
Thanks, and I think I understand. So the mere fact that my organization in its name includes the term coalition does not necessarily mean that I fall within the parameters of Section 4, Sub 1, Sub A, Sub H. The Retired Beer League Hockey Coalition is not, unless it works with other organizations, is not a coalition, and the deletion of that term is meant to convey or alter the requirement, make clearer the requirement that unless you are working, one organization's lobbyist is working with another separate organization's lobbyist, these provisions do not apply. Is that essentially correct?
Minister.
That's right. It clarifies which reporting requirements are required for that group. So the member's correct if they're working with another one, and it's a group coming together that are of independent, then it would be different reporting requirements than if it's just one that's a registered coalition. So I think yeah, I agree with what he said.
Member.
Thanks. Then let's go to the second part of the bill. Second part of the clause 2, where Section 4, Sub 1, Sub I.1 is repealed, and this is an existing requirement for organizations that have requested funding within a 12-month period. So what is the requirement? Where does this requirement come into play now, and how is it different after this section has been repealed?
Minister.
Sure. So I think before I answer that question, I'll give the member and the public a little background about what the reasons are for the changes before us in general. Really a group of nonprofits, including United Way, Vancouver Foundation, some of the bigger ones acting on behalf of smaller ones, came to government and said, we are all for transparency. We really appreciate that we want to register our lobbying when we do it, but some of the things in here are really burdensome for they apply to everybody, but particularly nonprofits. And we don't think they necessarily add to transparency. So one of those sections feeds into the amendment that we're talking about right now, which is the requirement that used to exist before, if these things pass, would exist after this, which is that you would have to register every time you requested government funding. And you already do it when you received it, so that's very transparent. You've received funding, you register it in the lobbyist, everybody knows you've received it. But you can imagine, particularly nonprofits, they do a lot of requesting of government funding. So the requirement to register every single one of those requests, what we were hearing from that sector in particular was that is overly burdensome of an administrative burden on us, and we already are tightly squeezed when it comes to our administrative ability, and we want to serve the public instead. So they're very thoughtful changes, and this one, if passes, would say you no longer need to register your government requests for funding, but yes, you definitely still have to register when you receive funding from government, which is later on in the Act.
Member.
Thank you. So the key change there is there will still be transparency around, detailed transparency around organizations that have received funding from government as a result of lobbying, but not necessarily the same degree of transparency around requests that have been made but did not result in funding. Is that correct?
Minister.
Yeah, just with a couple slight nuances. So let's say that organization did a lobbying activity for that funding. It wasn't just an application. They actually met with an elected official and said, you know, I really I'm lobbying you for this money. They would still have to register that activity, but not the request unless it was successful. So it's a little bit nuanced. Also, I think one of the reasons that organizations were asking for this is that government also has a very often, there's another side of transparency there with the process used for selecting grant applications and all the other, that side of the transparency that's covered. So we think it's like a good way to lower administrative burden that's unnecessary but not compromise transparency.
Shall Clause 2 pass? Aye. So ordered. Shall Clause 3 pass? Aye. So ordered. Shall Clause 4 pass? Member.
Thanks, Honourable Chair. So we appear here to be dealing with a situation where there's an attempt to define in more detail in what circumstances a monthly return needs to be filed. So my question is not dissimilar from the other ones, initial questions I've asked with the preceding sections, clauses, and that is what has arisen, what is the genesis or the source of the change? Is it an issue that has been raised by those obliged to file, or is it something that is it in response to concerns that the registrar themselves have raised.
Minister.
Okay, so there's three things that I'll talk about with this section just generally to explain the amendments. So first of all, section 4.1, the change that is made is us making it subject to section 4.4. And section 4.4 talks about final obligations when you're stopping yourself from being a lobbyist. So you're not going to be a registered lobbyist anymore because you're done your lobbying. So when there are final obligations, the timelines are different, and that those are set out in section 4.4. So that change, the rest of it doesn't change. The bottom part of it, so from like subsection 2 to 5. Nothing in the content has changed there. It's just organizational changes. So the thinking behind that was that it would be easier to put all of those requirements in one section for clarity purposes.
Member.
Thanks, Honourable Chair. So is the registrar contemplating specific changes to the form and manner that have informed this proposed amendment?
Minister.
Sorry.
Minister.
No, the registrar is not contemplating changes in that regard.
Member.
It's looking at 4.1 sub 2. I was trying to ascertain how this was manifestly different from the original 4.1. So I'm now looking at what is referred to in clause 4 of the bill, referencing 4.1 sub 2 of, and how that how that is actually and practically different from the original 4.1.
Minister.
So that subsection used to be 4.2 subsection 4, and there's no difference in the content. It's just moved for the purposes of better organization of the legislation.
Member.
And if we go to what is in the bill 4.1 sub 4, and I see the reference to 5 consecutive months. Any magic in that? Is that a holdover from an existing provision, or is that what was the rationale around 5 months?
Minister.
So this subsection is like the one we previously talked about where it hasn't actually changed in the content. The member asked about the 5 consecutive month timeline. That time period hasn't changed from previous versions of this legislation. And every time we do anything, we consult with the registrar to see if any changes are needed. So I'm assuming by that this timeline was appropriate.
Member.
And then lastly, Honourable Chair, in sub 5, there is the reference to, it sets out the criteria by which termination can occur for a designated filer, and termination of the registration of the lobbyist. And it firstly sets out the criteria for that 30 days after the monthly return under subsection 4 was due. Is that a discretionary matter, or does that follow automatically? And so that's the first question. Is there a discretionary authority, or is it an absolute requirement, an automatic requirement that the designated filer, the registration of that lobbyist is terminated for failure to comply with sub 4?
Minister.
Thanks. It's not discretionary after that. It is terminated after 30 days as written out in the rest of the section, so not discretionary.
Member.
Thanks, Honourable Chair. So let me just ask this then in a practical example. So I am someone who is covered by these provisions, lobbyist and designated filer. I have not filed my monthly, done my monthly filing in accordance with 4.1 sub 4. And 3 months later, I begin to file my monthly filings again, but technically I'm no longer registered. Have I sort of explained the kind of scenario? Does it, to be terminated, does it require an act by the registrar to formally terminate and notify the registrant that they've been terminated, or or is it just deemed to have taken place, and the designated filer, the lobbyist, must re-register and be aware of that?
Minister.
So what would happen in practice is they would, when they went to go register, so to log in, they would get a notice that their account was deactivated because of the time lapse, and then they would have to re-register.
Member.
Thanks, Honourable Chair. I think the attorney has hit the nail on the head there. And are they allowed to rely on that? So in the example I've given, if I don't receive that notice or that indication, am I entitled to assume that, notwithstanding that I have not complied with the provisions of that we are dealing with around monthly filing, if I don't receive that notice or indication that I've been terminated, am I entitled to assume that my registration remains valid?
Minister.
So there's no requirement for the registrar to give notice under this, but I just want to differentiate between this and enforcement provisions. So there may be times where the registrar needs to enforce lack of compliance with the rules in the Act, but that's a separate provision. This is just a situation where somebody just hasn't. It's basically like an active registry or registrant where they just haven't registered lobbying after a certain period of time and it expires. So it would just automatically do something. They would receive notice of that if they tried to go in again.
Member.
Thanks, Honourable Chair. And I'm just trying to think of this from a practical point of view, that and that this situation not happen, that a designated filer or lobbyist who is required to file on a monthly basis misses a couple of months, then resumes and may continue to resume for a year or two in full compliance with the legislation, only to have someone come along later and say, but 2 years ago, you missed 2 months and you're automatically terminated. It strikes me, and I will presume to answer my own question, that if the registry is continuing to accept filings, that the lobbyist is entitled to assume that their registration means it remains valid. But that's what I'm trying to confirm.
Minister.
Thank you. So I've been assured by the registrar that the regime is really focused on trying to be as low barrier and accessible to get people to register their lobbying. So we start with that, but that in the situation where somebody has been inactive for, I think it's 6 months in this, where their account is terminated, there's a few things that could happen. First of all, there's a process for reactivation of that account. They could register again, and And I'm sure that would be done in a way that is as low barrier as possible.
Shall Clause 4 pass? Aye. So ordered. Shall Clause 5 pass? Aye. Member.
Thanks, Honourable Chair. Third-party sponsors, are there, I see the interplay between the deletion of sections 4.2 sub 4 to sub 9 and then the changes to sub 10 reflecting that. I think my general question is how does this change collectively, these changes, the obligations that third-party sponsors have to provide information to the registrar?
Minister.
Thank you. So essentially, it doesn't change anything that doesn't currently exist as obligations on third-party sponsors. So one part of it that we already talked about is the subsections 5, 6, 7, and I think 10 and 11? No, sorry, that's it. Okay, so those ones, we mentioned the changes that were moved into the other section 4 just to add organizational clarity. The one change that is really like a consequential amendment is later on in clause 3, it talks about the changing of, I'm sure we'll get to that, monthly reporting to every 3 months. And that just 2E, subsection 2E2 adds that, makes that change. So those are the main aspects of this clause.
Shall Clause 5 pass? Aye. So ordered. Shall Clause 6 pass? Aye. Member.
Thanks, Honourable Chair. Let's again begin with the general question about the dealing with the form and content of monthly returns. It strikes me that what the ministry is attempting to do here is either add some things or bring some additional clarity, and I wonder if the attorney could confirm for the committee which, or if it's both, in what way the amendments are intended to accomplish that.
Minister.
Chair. So this comes from, again, the work that we did with particularly nonprofit organizations related to the administrative burden of this act. So what this change does is it changes the reporting requirements for government funding received for up to 3 months. So you could still report every month, but you won't be in breach if it's up to 3 months after you've received that funding, and it gives the organization the leeway to be able to address the administrative burdens of reporting, but still gets at the transparency that we're looking for.
Member.
And as a consumer of information contained or released by the registrar and the public lobbyist registry, how will this change what information I or a member of the public are able to receive?
Minister.
So it's all the same information that would be required as exists already. It just gives that grace period of up to 3 months in terms of reporting when you've received government funding.
Member.
Thanks, Honourable Chair. Let me ask to what degree, or maybe it applies to all of them. So I'm thinking about third-party sponsors, senior public officers, election advertising. Is everyone captured by these provisions?
Minister.
So the same definitions of how the Act applies generally would apply to these provisions. So it's consultant lobbyists or any lobbying organization very broadly.
Member.
Thanks, Honourable Chair. So when in terms of how the registrar reports information, am I correct that there would need to be a notation that the information contained released by the registrar is accurate to within, well, it's accurate on the basis of what people have reported, but would have to disclose that additional activities could have taken place within the previous 3-month period that are not, that would ultimately be reported, but have not been reported and need not be reported for up to 3 months instead of up to 1 month. So the accuracy of the information is altered to that extent. It's accurate to within a 3-month period, not a 1-month period.
Minister.
So organizations would still be required to report their lobbying monthly. So the only change would be is that if you've received government funding, it's up to 3 months you have to register. I think this is in line with a lot of other jurisdictions in terms of timelines of reporting when government funding is received.
Member.
Thank you. And the impetus for this change as it related to government funding came from the organizations themselves, the registrar, the ministry, or all three, or one of the three.
Minister.
They specifically came from a lot of work that was done from organizations representing the nonprofit sector, and it was bigger organizations like United Way BC, Vancouver Foundation, Vantage Point. They conducted a big study of some of the administrative impacts of various things with government, but particularly the Lobby Act, in light of like balancing transparency versus administrative burden. And this was specifically one of the things that we consulted with them that found that balance of lowering the administrative burden, but still having the transparency.
Shall Clause 6 pass?
Aye.
So ordered.
7 and 8 can pass.
Shall Clause 7 through 8 pass?
Aye.
So ordered. Shall Clause 9 pass? Member?
Get the sheriff. Get Omar the Sharif.
We'll take a 5-minute recess to get the support staff. Calling the committee back to order, recognizing the Attorney General.
Thank you, Chair. I just wanted to introduce my new team that's jumped in on these provisions. So I have Jenny Manton, the ADM for Court Services Branch, and Aaron Turner, the Director of Policy and Legislation. And I want to thank them for their work.
Shall Clause 9 pass? Aye. Recognizing the member for Abbotsford West.
Thanks, Honorable Chair. So definitions of emergency vehicles and capturing a sheriff's vehicle in ways that it is not apparently captured now. Where was the gap, and what are we trying to fix here in terms of is it a sheriff's vehicle for the purpose of doing what sheriffs are generally doing, which is transporting people to and from courts and correctional institutions, or is it other types of sheriff's vehicles? And where was the gap that this is intended to address?
Minister.
So this is something that not only the sheriffs have asked for, but also is to promote the health and safety of not only the public, but also the sheriffs. So currently, as it stood, they were allowed to turn on their lights when they had a prisoner on board, but if they were on duty but encountered an emergency and pulled over to assist, they're not technically allowed to turn their lights on. And you can imagine that creates a safety challenge, not only for the sheriff that's parked on the side of the road to get out of their vehicle, but also the individual they're assisting. So this just makes sure that that situation is captured under this legislation.
Member.
So the mechanics of accomplishing that are, am I correct, to eliminate the words from the section that created the limitation on the use of emergency lights and sirens and that sort of thing?
Minister.
Yes.
Member.
And not to suggest that anyone within the sheriff's service is going to abuse this, but the result of this is if I'm a sheriff, I'm in my vehicle, I'm not transporting a detained person, but I receive information of any sort that causes me to think I should lend assistance in an emergency situation. I can put my emergency lights on, I can put my siren on, and for all intents and purposes, I am now entitled to the same designations, protections, and abilities to operate on the road as a police car, an ambulance, or a fire truck, other vehicles who are captured by the emergency vehicle designation.
Minister.
So I just would, an opportunity to plug our great sheriff service in this province. They're very highly trained, very exceptional individuals that show up for the safety of our courtrooms every day. And they already have a statutory duty under the Sheriff's Act to take action to provide assistance in circumstances where they might arrive first at the scene, like in a motor vehicle accident. What these changes do is just enhance the safety of that situation. So they're allowed to turn their lights on to protect themselves and also whoever they might be assisting and any traffic that's passing by.
Shall Clause 9 pass? Aye. So ordered. Shall Clause 10 pass? Aye. Member.
Thanks, Honourable Chair. Can the attorney, with the assistance of her very able staff, paint a picture of an accident scene and how this would now operate, why it's required, and how it operates to authorize sheriffs to do something tomorrow that they are not entitled to do today?
Minister.
As mentioned before, what this does is enhance safety. So if they're first on the scene, beforehand they can only use their hazard lights. So this allows them to use their emergency lights and direct traffic if needed for the safety of that scene. And if the police arrive and they're still asking or in need of assistance from the sheriffs to continue to direct traffic, they could do that.
Member.
Does this, my impression is that this in no way alters the authority or the power of a peace officer, a police officer being part of that definition. A, is that the case? And B, it expands the range of authority to specifically include and vest upon a sheriff the authority that a peace officer presently has.
Minister.
That's correct. It in no way changes the definition of peace officer or their authorities.
Member.
I don't have the Motor Vehicle Act in front of me, so it may be, I suspect, that other sections provide an answer, but I'm going to avail myself of the attorney and her staff. In the subsections of this proposed clause 123, replacing the existing 123, where it speaks of preventing injury or damage to persons or property and permitting proper action in an emergency. Are there limitations built into other sections of the Motor Vehicle Act around where that applies or how that applies in terms of motor vehicle related incidents? And I'm trying not to be fanciful here, but a sheriff that happens upon a bank robbery scene, do these provisions apply in that circumstance where there's not necessarily a motor vehicle incident at play, but most people would say there is a threat to public safety nonetheless?
Minister.
Thank you. So what this provision does is really define the role of the sheriffs in a clear way. So if a sheriff considers it necessary to ensure the orderly movement of traffic, to prevent injury or damage to person or property, to commit proper action in emergency, and that's kind of been triggered and they're very highly trained, so they would be able to assess that, then they can assume the role of turning their emergency vehicles lights on and directing traffic. The very first thing would be to call the police as they're trained to do so until there's action. So in any number of scenarios, and the member raised one, if those are triggered for the sheriff in that assessment of the situation, then yeah, then the ability to turn the emergency lights on and direct traffic would be at play.
Member.
Thanks. That's helpful. And in the context of the Motor Vehicle Act, what the attorney has said makes eminent sense, that they would lend assistance in terms of the, as it says in sub A, orderly movement of traffic. But there are then sub B and C, which speaks about preventing injury or damage to persons or property, and then a very general one, permit proper action in an emergency. What are those intended to cover? They presumably are intended to convey some additional authority and I suppose some additional responsibility on sheriffs. The first one's pretty self-evident. The other two, sub B and sub C, less so.
Minister.
So all of these are contained in the sheriff's ability to direct traffic. So in the context of that, and enact their emergency lights, which is what we talked about previously. So in the context of that, if they determined that it was needed to prevent injury or damage to a person or property, or permit proper action in an emergency, then they could take on that responsibility of directing the traffic accordingly.
Member.
Thanks, Honourable Chair. So I think we've come around to more or less answer my initial question. These additional powers / responsibilities are restricted in their application to traffic management related issues. Is that correct?
Minister.
Yes.
Member.
Thank you. So here's my last sort of more general question that relates to something going back 100 years when I sat in the attorney's chair that I was curious about. In the Lower Mainland, in the metro areas, the sheriffs are hard pressed to fulfill their duties. There have been issues in the past around retention. I suspect my colleague will canvass some of that with the attorney at the appropriate time in the spending estimates. All to say, sheriffs in those areas don't tend to have a lot of spare time. There are other parts of the province where courts perhaps are less, where they may have more time available, and their responsibilities to the courts end at certain parts of the day or times of the day. And I recall being asked by sheriffs from those areas located in those parts of the province, look, we get training in some of these areas around traffic management and traffic safety. Why not let us put that training to work? This section speaks of an emergency situation where sheriffs happen upon the scene and just coincidentally happen to be there. But has the attorney thought about circumstances where sheriffs who receive this additional training, we've heard about that again today, might actually be deployed, and why am I interested? Why should someone be interested? Because in some of those parts of the province, we have dramatically elevated levels of crime, and it might free up police officers to investigate other forms of criminal behavior. So it's a way of perhaps sharing the burden a little bit differently, tapping into the expertise and apparently the interest sheriffs at one time had to fulfill some of those traffic management related functions, and allowing police to focus their attention on other areas of public safety that are equally, if not more, important. Long-winded way of saying, is the attorney open to the idea in situations where sheriffs have the time and have the interest to actually deploy them purposefully and on a more regular basis to traffic management duties?
Attorney.
I'll start by saying that sheriffs play and the member would know that, very, very important role in terms of the proper, safe conduct of our justice system. And that is in the courtroom and transport of accused. It's very key, and we are actively recruiting and retaining sheriffs to get more and more into our system. So that's my primary focus right now, and I really see the good work that they do. We've recently done a lot of work to understand how to strengthen and grow our sheriff service, and one of the things that we heard from that is sheriffs are asking about scopes of practice and what that might look like in today's environment. And so we do intend to engage in the service on that conversation, but you know, and we're open to that, but I think it all comes under the context of their primary role, which is in our justice system.
Member.
That's fair. I'll try to explore that just briefly. No argument for me that the primary responsibility remains with, for sheriffs remains the justice system, proceedings in courts, and the safe transfer of detained persons to and from the courts, whether they are in a local downstairs lockup or at a provincial or federal corrections facility. And people are undoubtedly not aware that every day that happens on a fairly widespread basis, where detained persons are brought to and from the courts. No argument for me that needs to remain the primary focus. the attorney has confirmed that sheriffs, not in all parts of the province, but in some, have made the case that where those duties, where they are not engaged in those duties, rather than sitting around, they'd like to put their training to work in other areas of public safety. And my general question is the attorney open to exploring that conversation with sheriffs and exploring the possibility in circumstances where it is appropriate, an expanded scope of work practice?
Attorney.
Yes, I am, in the context of the deep work that we're doing with our sheriff's service to uplift not only the work that they do, but to support them, because we know how vital they are to our court services. So I am open, and our team is open to engaging in conversations with sheriffs of what that might look like, and I will not predetermine the outcome of those conversations here.
Shall Clause 10 pass? So ordered. I understand there's been shall Clause 11 pass? So ordered. All right, I understand there's been a request to stand down Clause 12 until, I believe it was 19, and to begin with Clause 20. Acting House Leader, I should have that request officially.
Yes, thank you, Chair. Can we please stand down Clause 12 to 19 as the Minister is in estimates?
All right, so we are going to stand down Clause 12 through 19, and that means we will be starting with Clause 20, which is relating to the Ministry of Finance amendments. So we'll just wait for the appropriate parties to join the House, and we'll get going.
Thank you. We'll request a 5-minute recess.
Acting House Leader requests a 5-minute recess. I grant such a recess. Please come back promptly. Thank you. All right, members, let's call this committee back to order. We're here with Bill 9, starting on Clause 20. Attorney General.
Thank you, Chair. I just wanted to take a moment to thank the team that's joining me here from the Ministry of Finance. We have Tiffany Norman, Executive Director, Policy and Legislation Division, and Matthew Ong, Strategic Advisor, Policy and Legislation Division. I just want to thank them for their work and for joining me.
On Clause 20, member for Kamloops North Thompson.
Thank you, Mr. Chair, and I recognize and thanks the Minister for filling in for the time being, and obviously the staff will be providing much more nuanced answers. That's to the Minister to provide to us, so that's great. First off, can the Minister explain the implications that this definition repeal will have on the general public's understanding of an insurer?
Attorney.
Thank you. So from the perspective of the general public, it provides clarity to what the definition of insurer means, to make it clear that it always means an insurance company. And that's consistent with other acts in terms of the definition of insurer.
Thank you. And in this clause, they're also adding a definition around personal information. I can get that it has the same meaning as it says, as the Freedom of Information and Protection of Privacy Act. Why was there the need to insert personal information into Clause 20 as well?
Attorney.
Thank you. So the reason for the addition of this definition that the member pointed out was because in Clause 29, which I'm sure we will get to, it uses the term personal information. So because of that, it required a definition.
Member.
Thank you. And what are the anticipated impacts on regulatory oversight and consumer protection by altering the definition of an insurer to exclude agents and adjusters?
Attorney.
So there generally is no impact to the member's question. What this does is really provide clarity that the definition of insurer means insurance corporation. But in particular instances, which are in the Act, when it does need to mean something broader, it expressly says that or includes that.
Member.
Thanks for that. So will this change in definition in any way affect the responsibilities and liabilities of agents and adjusters compared to insurers?
Attorney.
No.
Member. Thanks. And what prompted the decision to redefine insurer within the context of the One FSR project and ongoing regulatory reforms?
Attorney.
So the sole purpose of these amendments was to seek the clarity that I described before.
Member.
Thanks. Is there any specific case studies, incidents, or anything like that that have led to the redefinition? Is there highlighting that there needs to be the need for the clear distinction between the entities?
Attorney.
This is largely just a housekeeping matter where upon review of the Act, the team here identified that in reality, most uses of the word insurer just referred to the insurance corporation, and just those exceptional uses that didn't include that. So it was just a matter of housekeeping to clarify.
Member.
Thanks. A lot of times changes like this are made to try to better align with either other national, provincial provinces or similar jurisdictions, international standards, that type of thing. So does any of this redefinition align with, or was it checked to see if it will align with those regulatory changes that may have been happening with international standards or on financial services regulation?
Attorney.
Thanks for the question. Yeah, you're correct in that, in pulling that up in the sense this new definition does align with the Insurance Act and the financial services legislation of Canada and other provinces, which is something you always seek to do with financial legislation.
Shall Clause 20 pass? Aye. So ordered. On Clause 21, member for Kamloops North Thompson.
Thank you. Just a question or two on this clause as well, Mr. Chair. Can the minister provide an example of how this substitution will impact people in our communities?
Minister for Advanced Education.
Thank you, Chair. With us in the gallery today, we have a group from the Ministry of Health and the Provincial Health Team. And so I'd like to take the opportunity to welcome them to the chambers. We're having some exciting debates here today. And if everyone would please join me in making them welcome.
Thank you to the Minister of Post-Secondary Education and Future Skills. Attorney.
So this doesn't change the meaning of anything, nor does this change impact the public. It kind of is in line with what we were talking about previously, which is that the definition of insurer, so as defined to mean insurance company, that there are instances where that definition doesn't fit. And so this is one such instance. So the section 66.2 requires an insurance company to be a member of a prescribed insurance compensation plan. So it's not just an insurance company, it's an insurance company that's a member of an insurance compensation plan. So then the definition was switched to entity just to make sure that there was a distinction noted there and there was clarity provided.
Shall Clause 21 pass? Aye. So ordered. Clause 22, member.
Thank you, and I know the minister on the previous clauses was there was a lot of discussion around electronic filing and access and things of that nature. In clause 22, can the minister provide an example of how people will be able to access copies of the forms once they are filed?
Attorney.
Thank you, Chair. So in this circumstance, it's not a public-facing document. I'll just explain what's just been explained to me, which is that in this instance, it's about an insurer would already have a form that they may have filled out with the client or whoever they're working with. And in this circumstance, a superintendent may order that that insurer, and that's defined under the sections, file a copy of that form with them to see if it's in compliance with the rest of the regulatory regime. And so it's not really a public-facing thing, it's more of an internal thing for regulation.
Member.
Thank you, and were stakeholders like insurers and the licensees consulted on the language changes, and if so, what feedback was incorporated into these changes?
Attorney.
So the substantial change here is a change from insurer to insurer or a licensee under that section. So it doesn't really change any obligations or requirements that are currently on insurers or any other stakeholder in the legislation. It just provides that clarity of what is meant or what is needed to be meant by adding it on top of insurer by including licensee. So because of that, there was no consultation needed to drive any changes of policy. It was merely a housekeeping issue.
Shall Clause 22 pass? Aye. So ordered. Shall member on Clause 23.
Thank you. Just to confirm with the minister that I'm reading this correctly, so this seems to be that it's adding a requirement that the sale of insurance through the use of an electronic agent meet the requirements established in rules made by the Insurance Council of British Columbia, as well as those established in rules made by the BC Financial Services Authority. So this would indicate to me, this means if you go online to access an insurance product, it has to meet the standards that a product being sold in BC would typically meet, even if the electronic agent or institution that we're accessing electronically is from a different jurisdiction.
Attorney.
Okay, just in terms of the purpose of these provisions, as it was just explained to me, what the purpose of it is the BC Financial Services Authority at this stage has the regulates insurance companies, while the Insurance Council regulates licenses and regulates insurance agents and salespeople. So in that context, we have two regulators, and under the current regime, the BC Financial Service Authority has regulatory making power, or the authority, rulemaking power, but the Insurance Council doesn't. So these changes add the council into the provisions under the, you'll see the amendments, it adds the term "or the council" as applicable, just to clarify that. And I know the member asked a question that if he could just give us some more clarity in terms of what that was, and then I'll try to see if I can answer it.
Member.
Thank you. Well, the question I had actually was derived from the explanation in the bill in terms of what Financial Institutions Act Section 92.2, which Clause 23 deals with, and that the explanation is adds a requirement that the sale of insurance through the use of electronic agent meet the requirements. I guess the question is this just for the sale of insurance products internal of BC, but through an electronic means? In other words, I electronically communicate with an insurance agent in Kamloops while I'm down in Victoria to deal with an insurance product, or is it also that I'm able to electronically deal with an insurance agent in Alberta or Ontario through electronic means, but that agent would then still have to actually be abiding by the regulations within British Columbia?
Attorney.
Yes, so the member got it correct as I understand it. So even if it's outside of BC, the province of BC, the trigger point is a sale to somebody that's located in BC, and if it's a call center that's in Alberta or some other jurisdiction, and that is happening, then they are required to comply with the rules under this regime.
Member.
Thank you. And I asked this question somewhat with the backdrop of what we see happening in the gaming world. So, you know, there's all sorts of rules around what you can or can't do in terms of online gambling. You're technically not supposed to be on Bet365 if you live in BC or any of the ones. But there's workarounds, there's VPN, there's all this type of thing. There's, you know, you just click the box, and some are bad actors. They don't really geofence their product very well. Others are very reputable operators, and they stay within the confines of the province they're supposed to operate in or the jurisdictions. So what type of oversight, is there any ramping up within these agencies to make sure there's proper oversight and scrutiny and auditing or things of that nature to make sure that online access is reasonably meeting that standard of meeting what is supposed to be happening under British Columbia law in terms of the provision of those particular insurance products that people might be seeking out?
Attorney.
Thank you, Chair. So the general oversight, the member asked a question about compliance, enforcement, and oversight to the regime. The general ability to do that is under the BC Financial Services Authority and the Insurance Council as independent regulators. They have the compliance, oversight, and regimes, which include penalties and all the things in their toolkit to, the change that this does is add to clarify in certain circumstances where the insurance council would have that rulemaking power. So in a sense, it broadens their ability to do some of to regulate over certain things.
Shall Clause 23 pass? Aye. So ordered. Shall Clause 24 pass? Oh, member for Kamloops North Thompson on Clause 24.
Thank you. I'm just double checking to see if they want to swap ministers before I dive into this next clause or not. So, okay. So clause 24, this is about amending in subsection 1 by striking out within 90 days and substituting within prescribed period, and 1.1 by striking out within 60 days and substituting within the prescribed period. Can the minister provide an example of the timeline that this new prescribed period will come into effect, given that we had fairly clear definitions in the legislation in terms of 90 days, 60 days, and now it's a little more open-ended of a within prescribed period?
Attorney.
Okay, so the reason for these changes is to provide flexibility in those timelines and to also to align, as is important with financial laws, with other jurisdictions like Saskatchewan, Ontario, Quebec, Prince Edward Islands, and Newfoundland and Labrador that also have prescribed deadlines. And the deadlines will be put in through regulation, and there will be a consultation process with industry to decide what they will be. So they will be listed out in regulation. And one of the reasons is there could be sometimes conflicting financial reporting requirements from a parent company with their subsidiary, something like that. So that's why there was a need for flexibility in the timelines.
Member.
Thank you. Well, the minister touched on partly what my follow-up question was going to be, and that's around a timeline for actual implementation. And this section, I note, is comes into effect by way of order in council, not oral assent, as most of the rest of the clauses in the financial sections of the miscellaneous stats bill do. So I'm just wondering, what is the expected timeline for clause 24 to actually be truly amended and in effect? I recognize we're amending it today, but the real meat of it is, when does it actually truly take effect? So what is the anticipated consultation and then turnaround with an OIC to move forward with this?
Attorney.
So I'm told by the team here that the goal is to have the regulations in place as soon as possible, but will depend on the consultation process, but there's no set timeline.
Member.
Well, thank you. I think everyone would hope that government would do things as soon as possible, but that's not the reality. So looking for a little bit more clarity on that timeline, I guess, and particularly with the backdrop of a looming provincial election. So how does the election factor into the timeline for consultation, and can this consultation and then order in council be done before a general election, a writ drop? Basically, we have until around the beginning of September, second week of September, and then the business of government starts to come to a halt in terms of things like this, is my understanding how government typically works, regardless of political stripe because of the election. So is there an expectation that this will all be wrapped up before the writ period and we'll see the OIC then? Or is this one of those changes that could be lingering out there for a quite extended period of time, actually?
Attorney.
Okay, so we don't expect this to be a contentious issue, and one of the things that consultation is important. One of the things that we can guide this is the fact that other jurisdictions have prescribed regulations where they set out timelines, and oftentimes in this type of regulation, we do try to mirror other jurisdictions. So, given the fact that we're going to be working on it as soon as possible, it is possible that before, in this mandate, we would have the regulations in place.
Member.
Thank you. So one thing that's always intrigued me with the post-2020 election is the fact that with the government having a very firm number in the majority, it's not like the first 17 to 20 time frame where, depending on the day and who's not feeling well, the government may or may not fall. There's obviously a stronger base of votes for the government to move through legislation, so they can bring forward legislation with pretty good certainty it's going to pass. I guess unless it's the Land Act, and then it doesn't come forward at all. But in terms of this, why was there not consultation already happening if it's not expected to be contentious, if it's going to be built primarily on what other jurisdictions are already doing? I mean, frankly, this government has people sign NDAs all over the place to work on things ahead of time. Why, in this case, on something, especially with the backdrop of a looming election, was there not already that work being done so that maybe not sign off by the time this bill comes forward from the institutions, but pretty close to knowing exactly what was going to happen in terms of those regulations, and so that we could see them advance forward perhaps quicker. I'll give the minister a couple examples. We had housing bills where we spent days asking the minister what the regulations were going to be, and the minister said he can't provide those answers because they're still working on them, and then 5 days later there was a 57-page document of regulations and rules around housing release publicly after it was passed. We had FOI legislation where we were talking about fees for days on end, and the minister couldn't provide because the government was still consulting and they were still working on it. And literally minutes after the bill was passed and royal assent was given, the regulations magically appeared. So I'm just wondering why in something like this, the government, if it's truly not meant to be contentious and meant to just align with what other provinces are doing, why that work hasn't already been started in anticipation of this bill passing, knowing that government has the majority and will pass regardless, let alone it's not contentious, so it's not like the opposition is opposed to this. But it just seems like this is going to be a piece of legislation that people will hear about, think changes have been made, and then find out, in fact, it's not actually law because it has not come into force and effect yet because we're still waiting for Cabinet to sign off. So why has there not been that pre-work done in this case?
Attorney.
Thank you, Chair. So the reason for these particular changes from a 90 days to prescribed period is because we heard from people that there was a need for more flexibility. We are following nothing more than the proper procedures related to legislation, where we wait for royal assent before we go out to consult. But as I expressed to the member, we don't expect it to be contentious. We expect there to be lots of other examples that we can use from in terms of what that prescribed timelines or periods could be in different scenarios, and we would expect that we could put them in place as soon as possible.
Member.
Thank you. Can the minister then share with us what is out in Canada right now for typically actioned prescribed timelines, so that we have a ballpark window of people can reasonably expect the timelines will look like of what a within a prescribed period would look like once that consultation is done?
Attorney.
Thanks, Chair. My team over here is looking for answers, but in the interest of time, if the member wants to ask another question, we can get back to him on other examples.
Member.
Sure, and I think it is important because the whole consultation is going to be based on, as the minister has said, what other jurisdictions are doing and the intent to align. And so if it's truly not that consequential in terms of being confrontational with the industry, it should be a fairly quick and smooth and easy process. But that's also why I'm confused why it hasn't started. And I guess maybe just to clarify with the minister says, well, we don't consult until royal assent on bills when it comes to regulation. Royal assent on Clause 24 is completely irrelevant because Clause 24 is by order in council. So the rest of the bill matters for royal assent for the most part. Clause 24 and 25 don't. So I guess trying to reconcile the minister's previous answer around not consulting because of awaiting royal assent on this bill when it's actually order in council that will then trigger this clause to come into effect by law. Again, given the potential complexities, as the minister has said in a previous answer, around other factors like filing dates and periods that other head offices may have, and not wanting to conflict with that, but at the same time actually, so it sounds like the ministry is well aware of these potential impacts. They're well aware, though, that they also want to align it with more of what's going on in the rest of the country. What is, again, why not the pre-consulting, and why can't we at this point publicly acknowledge the ballpark of what the government is hoping to get to with these regulations, given that they're going to be based on national standards? One would assume when the bill was being drafted and with the intent that the ministry staff would already know somewhat what they were driving towards for an endpoint, or it's a strange way to bring forward changes if you don't even have a ballpark order of magnitude that you're trying to get to have an endpoint.
Attorney.
Thank you, Chair. So just to answer the member's question, the law until we receive royal assent and this becomes law is 90 days and 60 days. Once it switches, if this is past its prescribed period, then we have the ability to speak and do our consultation process with the community or the stakeholders at issue to get a really good made in BC solution for the prescribed timelines. And with that, I move that the committee rise, report progress, and ask leave to sit again.
Members have heard the question. All those in favor? Aye. Opposed? Carried. Thank you, members. This committee is adjourned.
Committee Chair.
Thank you, Honourable Speaker. Committee on Bill 9 reports progress and seeks leave to sit again.
When shall the committee sit again, Government House Leader?
Next sitting, Speaker.
So ordered. Members, I am advised that Her Honor Lieutenant Governor is in the precinct, so please remain seated, and we will advise you as soon as she becomes available, and we will continue with our procedures.
Sorry, Rob, is it next sitting? Do I need to say immediately or next sitting?
That's fine. We understood you. We'll be sitting later.
Employment Standards Amendment Act 2024. Municipal Affairs Statutes Amendment Act 2024. Child, Family and Community Service Amendment Act 2024. Social Development and Poverty Reduction Statutes Amendment Act 2024. Atlee Gwai Legacy Trust Winding Up Act. Commercial Transport Amendment Act 2024. In His Majesty's name, Her Honour Lieutenant Governor doth assent to these acts. Supply Act Number 1, 2024. In His Majesty's name, Her Honour Lieutenant Governor thanks His Majesty's loyal subjects, accepts their benevolence, and assents to this act.
As always, it's wonderful to join you today. I have to say, I really do enjoy these opportunities to come and see all of you. And generally when I come in, people seem to be smiling. I know it's only because it means you get some time off. But I understand you have a couple of weeks break. And I simply want to say, I hope you take that time to enjoy your families, get a little bit of downtime, relax, and I'll look forward to seeing you all again soon. Thank you so much.
Government House Leader.
Thank you, Honourable Speaker. In the main chamber, we call Committee of the Whole on Bill Number 9, Miscellaneous Statutes Amendment Act. In the Douglas Fir Room, call Committee of Supply for Ministry of Forests, and in the Birch Room, Committee of Supply for the Ministry of Environment, Climate Change Strategy.
Committee chairs.
Apologies.
Government.
Yeah. You have more? Okay.
Government House Leader.
Apologies, Honourable Speaker. In the Douglas Fir Room, call continued debate of the emergency management and climate readiness estimates.
Committee chairs.
We'll call the committee to order. We're dealing with Bill 9, Miscellaneous Statutes Amendment Act 2024. Shall Clause 24 pass? Aye. So ordered. Shall Clause 25 pass? Recognizing the member for Kamloops North Thompson.
Thank you, and I recognize that Clause 25 is worded other than the fact that Section 163 versus Section 127 being amended. It's the same in terms of striking out within 90 days and striking out within 60 days and substituting both of those within the prescribed period. So I recognize that on the front end. But I'm just wondering, is there any substantive difference between these two? In other words, is there going to have to be a totally separate consultation done on Clause 25 than Clause 24? If not, will you just be at the same time, and it's essentially the same topic, same issue, just two different clauses that need to be amended to make everything right within the legislation?
Minister.
Thank you. Yes, they're essentially the same in a lot of ways, so the consultation would be done together.
Shall Clause 25 pass? So ordered. Shall Clause 26 pass? Member.
Thank you. So Clause 26 appears to make it possible for agents to, insurance agents and employees to sell insurance across geographic boundaries within Canada. What prompted the decision to allow this to happen?
Attorney General.
Thank you. So under the Financial Institutions Amendment Act in 2019, what was added was the ability to have restricted insurance agents as licensees, but there currently aren't, that's not in force. Right now, the regulations and licensing regimes being worked on with the Insurance Council. But what the changes under this do is to recognize a common business model, which is that some restricted licensees utilize international or national call centers to do their work. And so this amendment will provide flexibility for restricted licensees to structure their operations as needed.
Member.
Thank you. Has there been any modeling done or concerns that this would further enable fewer and fewer people employed within British Columbia within the insurance sector, because they could have companies could be even more app-based driven, and as a result, your products and that can be accessed and serviced by, as the minister just said, call centers versus physical locations within British Columbia where there's a physical human behind a desk dealing with the customer's needs.
Minister.
Just important to put this in context. So these particular amendments or the regime that was related to restricted insurance agents and licensees or licensing them is about an area that is currently exempted and needs to be brought into a regulatory regime in a more defined way. So that's the work of this, not only these amendments, but the work since 2019 to add this. So these are examples where the sale of insurance is sold incidentally to the licensee's ordinary business. So you can think of examples where they're not insurance brokers necessarily, but it's incidental to their other business to have insurance as a product. So it makes it, once the regime's been put, would make it easier for the public to access insurance products when they're purchasing something else, which is happening already. So that was the reason that there's not a need to do modeling related to any changes that might happen as a result of these amendments, because it's just bringing maybe existing things into a regulatory regime.
Member.
Thank you, and bringing it into that regulatory regime, was there thought, or is there already still the protections then in place on things like, and we referenced it earlier about, personal information, things of that nature, in terms of if the call center that the person is accessing is in a jurisdiction that obviously has different information laws than British Columbia. Does the British Columbia protections still kick in for that person's personal information? We're dealing with insurance products. Typically, there's a lot of information that could potentially be shared at that point with the company, and I recognize the client might be doing it willfully and wanting to access that service, but they may not understand what jurisdiction they're actually phoning into or communicating on a chat, electronic chat back and forth, let alone what their privacy laws of that jurisdiction might be. So are there those further protections either within Clause 26 or elsewhere within the Act itself?
Minister.
Yeah, thank you. So yes, once this is brought into place so that there's licensees under the as a restricted insurance agent, then as we canvassed earlier, under previous sections, they would be expected to comply with all of the regulatory oversight related to the sale of that insurance product in British Columbia.
Shall Clause 26 pass? Aye. So ordered. Shall Clause 27 pass? Aye. So ordered. Shall Clause 28 pass? Member.
Thank you, Madam Chair. I'm just wondering if the Minister could tell us what will the process for disclosing information on or records for the purposes stated in this section.
Minister.
With respect to the perspective of the public, it doesn't change any of the privacy protections or personal information protections under any of the clauses in general. It's very specific to reduce the administrative burden of what was existing before, where the Insurance Council had to get the consent of the BCFSA to exchange information or through administering what is their responsibility. So what it does is it removes that requirement and removes that administrative burden in terms of their processes.
Member.
Thank you. So it says that the information or records described in subsection 1 may be disclosed. So it's still not a requirement that someone has to. It's at their discretion. But not needing the consent, and I get that, of speeding up the process of the BC Financial Services Authority or the superintendent, not have to be obtained anymore. Was this can we get a sense of the order of magnitude of how many times this was being sought, and was it over, were the BCFSA overwrought with requests and a big backlog, and that is what's prompted this change, or what is the true impetus for why this needs to be changed in the first place?
Minister.
So really these changes are to address an unnecessary administrative burden. And really the Insurance Council and the BC FSA regulate different areas of the professions. And we went through that earlier. So there was actually really no need for that extra step of consent because of their clear jurisdictions and the clear use of that information. So it just gets at removing that administrative burden that was unnecessary.
Shall Clause 28 pass? So ordered. Shall Clause 29 pass? Member.
Thank you, and I do recognize we're now at the clause that triggered the personal information being earlier on, and the definition being inserted earlier on. But can the minister provide an example of how a person will be informed about the reasons for and the uses of the collection of their personal information, and how that will be handled?
Minister.
So actually, this introduction of this provision is very specific and narrow, and it remedies something that was happening under the trust and deposit business exemption regulation. So the collection of a form requires the collection of personal information through a personal information return. So in order for that to happen, we need to clarify very clearly that not only is it allowed for them to collect that personal information, but it's also protected under FOIPA and all the other protections of privacy that would apply to that.
Member.
Thank you. And so I'm assuming then that there's provisions that also means that the person needs to be provided that level of detail about how their personal information can or can't be used?
Minister.
Yes, in amending this provision, we consulted very clearly with legal counsel in terms of our compliance with FOIPA and these amendments. So yeah, that would all fall into place with these amendments.
Shall Clause 29 pass? So ordered. Shall Clause 30 pass? Member.
Thank you. In 4.1 of this clause, it says a voting member of the council whose term of office has expired may continue to hold office until a successor is appointed, but there's no timeline spelled out for how long that process may be allowed to continue on for. So why is that, and what is the timeline that a successor needs to be appointed before that person is deemed to be no longer on the board?
Minister.
Thank you. Just want to put this provision in context. So as often happens when we contemplate legislation, we want to remedy in the instance of extraordinary circumstances to make sure that business can continue. So this is just part of our modernization of the board governance that is in line with a lot of board governance modernization. So there's a lot of other provisions in the Act that talk about timelines and appointments and assurances that there's the right number of people in the board governance structure. But in the instance where you can think of an exceptional circumstance like COVID, and we had a lot of exceptional circumstances there, where you have an instance where there is a council member whose term is expired, but there isn't a successor in place, it's important in that circumstances to have clarity that the business can still continue, right? That there still is a voting member in that instance. So it's meant to capture an extraordinary circumstance and to make sure that there's no gap in governance in that circumstance.
Member.
And I can totally understand and appreciate that. I guess the question is, it seems to be worded fairly open-ended in that there is no actual endpoint. It just says until a successor is appointed with no time frame whatsoever. No, they must appoint within 6 months someone else, and then a sub-clause to what happens if they're still unable after the 6 months. But at least something to indicate there might be a bit of urgency to try to figure out the situation and find someone. So is it truly open-ended? And if not, then where can the minister point to where that becomes no longer open-ended, and in fact that it forces the council to act maybe a little quicker to make sure that there's not that lack of a successor, I guess, because I mean this ties into term limits essentially, right, in terms of length of service on the council, and we've all seen boards out there and other decision-making entities where people really don't want to leave, or people want people to stay longer than they really are supposed to be allowed to, and there's ways to extend, and this seems to be a way for them to be able to extend without actually having an urgency to replace.
Minister.
Yeah, so as I mentioned before, this is in the instance of a pretty extraordinary circumstance because of the functioning of the rest of the Act that talks about appointments and how governance structures will work related to that. But there is an ultimate power that the Lieutenant Governor has to rescind an appointment in the situation of abuse that the member raised, and that would remedy any abuse of that provision.
Member.
Thank you. And so I'm assuming it's the BCFSA that would be overseeing the board in terms of how they're conducting and be the ones that might be alerted to needing to step in to remedy the situation?
For instance, it would be the Insurance Council of BC.
We're going to do a 2-minute recess. Call the committee back to order. Shall Clause 30 pass? So ordered. Shall Clause 31 pass? Member.
Thank you. So this is a clause dealing with if a voting member is unable to attend personally any meeting of the council, the chair of the council may nominate a non-voting member who is of the same representative character as the voting member to attend the meeting in the same place of the voting member. So I understand the idea around the phrasing of same representative character, so that in the context of a board makes sense. But is there any other criteria that the chair must follow of the council to abide by when choosing a non-voting member to attend the meeting in place of a non-voting member? Is that the sole criteria that the board chair has the sole discretion to invoke?
Government House Leader.
Thank you so much, Chair. And so staff have informed me that if a member is, for example, doing life insurance and is not available, it only can be somebody who is licensed as a life insurance official that can come in.
Member.
Thank you for that. And it also says that it allows the chair to nominate. So is the process the chair is nominating a name of a non-voting member to the rest of the council, and the council approves that name, and then that name is allowed to be a participant as a voting member or for that meeting, or is it at the sole discretion and appointment of the chair?
Minister.
Thank you, Chair. It's at the discretion of the chair, so the chair can appoint directly.
Member.
Thank you. And I'm making a bit of an assumption, but it's just better to have it on the record, I guess. The assumption would be that then that member would have full access. Obviously, the non-voting member that is now going to act in a voting capacity for that one particular meeting would have full access, including any in-camera type documents and discussion, and needed would be then signing off on the same code of conduct type scenarios that voting members would have already had gone through.
Minister.
Thank you, Chair. I was asking a few questions just so I'm grounded on all the pieces. And the member would be correct if he, as he says, that whoever is coming in would have access to the meeting's documents that are required for that meeting.
Shall Clause 31 pass? So ordered. Shall Clause 32 pass? So ordered. Shall Clause 33 pass? Member.
Thank you. This is K in section 225.1. Subsection 2 is amended by adding the following paragraph K for the purposes of section 92.22, establishing requirements for insurance agents and insurance salespersons who issue, deliver, or offer to undertake contracts of insurance through the use of electronic agents. So we've canvassed a lot on the electronic stuff leading up to this, so I get the broader concept here. I guess the question, though, is it's kind of general in saying it's establishing requirements, but it doesn't actually tell us what those requirements actually are. And why that's relevant is that 24 and 25, clause 24 and 25 were the only two that come into effect by order in council. This clause will come into effect by way of royal assent, and there's no real detail as to what the established requirements for insurance agents and insurance salespeople is going to be. So where would one be able to look up what those actual requirements are?
Minister.
Thank you, Chair. So two things. This is clarifying rulemaking authorities in this section. So the BC Financial Services Authority regulates insurance companies, while the Insurance Council licenses and regulates insurance intermediaries, including restricted insurance agents. So this amendment is technical correction to the Financial Institution Amendment Act in 2019, which incorrectly assigned the power to make rules respecting the online sale of insurance by insurance agents and salespersons to the BC Financial Service Authority. So the rules right now don't exist. There's a comprehensive process that has to happen. Public engagement still has to happen, and then it's got to come to the minister for sign-off before it's public.
Shall Clause 33 pass? So ordered. Shall Clause 34 pass? Member.
Thank you. So as I mentioned, we've done a lot of discussion on various clauses around online and online sales and all of that. So it's interesting, Clause 34 says it removes the requirement that the records published by the Insurance Council of British Columbia be published online. I guess it just seems like a reverse. You have municipalities struggling right now trying to figure out how they're going to have a newspaper record to publish in because there's not a physical newspaper, and we've had to change laws around electronic notifications being valid and legal, and yet here it seems like we're removing the piece of technology that everything is moving to. So I guess what is the logic behind saying that they no longer have to publish something online, and if not online, where are they reasonably expected to be publishing still for access for their members to be able to see what's going on?
Minister.
Thank you, Chair. So by crossing out online, it doesn't mean that they won't be online. They still will be, but now that they'll have the ability to also publish through print, through newspaper, through magazines, in different ways beyond just online. So online still will happen, but they also have the ability to do others as well.
Shall Clause 34 pass? Shall Clause 35 pass? Member.
There we go. I was up and down there a few times. I felt like I was back at church. So in Clause 35, how will the new enforcement powers enhance the regulatory body's ability to collect fines from current or former licenses?
Minister.
Thank you, Chair. The amendment will allow the Insurance Council to file with the courts an order imposing unpaid fines for contravention of the Financial Institutions Act and its regulations by licenses, former licensees, or any other officer, director, employee, controlling shareholder, partner, or nominee of the licensee or former licensee. And the unpaid fines will be debt owed to the Insurance Council that is enforceable by courts.
Shall Clause 35 pass? So ordered. Shall Clause 36 pass? Member.
Thank you. And this is striking out its powers and substituting the superintendent's powers. So am I correct in assuming that this is not providing any new powers to the superintendent? It's simply clarifying and a language change to better reflect who its powers is?
Minister.
Yes, the member would be correct.
Shall Clause 36 pass? So ordered. Shall Clause 37 pass? Member.
And again, just to clarify, 37, same as 36, this is just language cleaning up around its supervision versus the superintendent's supervision.
Minister.
Yes, Chair. Again, the member is correct.
Shall Clause 37 pass? So ordered. Shall Clause 38 pass? So ordered. Shall Clause 39 pass? Member.
Here we go. Let's see if I can go 3 for 3. So this is around Mutual Fire Insurance Companies Act. It's really looks to be just a housekeeping amendment, but is there any implications that will change in the definition of registrar in terms of impact to the general public?
Minister.
Chair, there will be no change at all.
Shall Clause 39 pass? So ordered. Shall Clause 40 pass? Member.
Thank you. In terms of, there's definitely been a rise in the difficulty of obtaining fire insurance, especially in wildfire-affected communities in the interior specifically. Will any of these changes do anything to help those residents that we're seeing on a yearly basis be more and more impacted on trying to access fire insurance as it relates to wildfire impacts?
Minister.
Thank you, Chair. So there's, important to note, there's only one company incorporated under this section. It's a technical change, and before it was really restrictive only to fire insurance, and now they'll be able to provide different types of insurance.
Member.
Thank you. So to clarify then, that this will enable them to provide other forms of insurance that they're currently not able to provide under the Act?
Minister.
Thank you, Chair. This one company that falls under this, by this change, it will better reflect, they'll be able to better reflect what type of breadth of insurance they offer in their name, in their title of their name.
Shall Clause 40 pass? So ordered. Shall Clause 41 pass? Member.
Thank you. So in what ways do the specificities of the new name compared to the ways that the Mutual Fire Insurance Company is named in other provinces, and what time frame does the Minister foresee the approval process taking for any new name?
Minister.
Thank you, Chair. This is a very technical change. There's only, for this piece of legislation is over 100 years old, and only one company is reflected in it. And so this just allows them to better reflect in their name the services that they provide.
Shall Clause 41 pass? So ordered. Shall Clause 42 pass? Okay, we will take a two-minute recess. Call the committee back to order. Shall Clause 42 pass? Member.
Thank you. Can the minister confirm that on subsection B of Clause 42, subclause B, it's simply creating a capital I to the word Indigenous? It's just simply a spelling correction?
Minister.
I think he just wanted me to stand up to say he was correct again, and I will.
Member.
Well, as much as I would, I like to hear the minister repeatedly tell me that I am correct. That wasn't really the case, but it's just because of course, some of these changes are very, very basic, and some we just want to make sure we're not missing some broader implication of a change. In terms of the overall change in Clause 42 and the definitions, what consultations, what was the consultation process like with the nation on changing definitions?
Minister.
Thank you so much, Chair. So the Shishal Nation was consulted and reviewed a consultation draft of legislation, and it's supportive of proceeding with the amendments.
Shall Clause 42 pass? Aye. So ordered. Shall Clause 43 pass? Member.
Thank you. Can the minister explain why in paragraph D it's being replaced with the Council of the Shishalish? I'm probably going to mispronounce it. It's not intentional. I do apologize to the nation if that happens. Rather than it as a nation government district.
Member.
Thank you. It's really just around the replacement of the council of the nation rather than the nation government district.
Minister.
Yeah, that's the name, the Shushala Nation. That's the way they would like to be referred.
Member.
No, I just answered my own question. That's okay.
Shall Clause 43 pass? Aye. So ordered. Shall Clause 44 pass? Member.
Thank you. Just if any of the changes in Clause 44, do they create any changes in the delegation of powers of duties for decision makers?
Minister.
Thank you, Chair. The amendment doesn't change the intent of the section, though.
Shall Clause 44 pass? So ordered. Shall Clause 45 pass? Member?
Thank you. Just to confirm, and the minister touched on it earlier with an earlier question, but around naming, by recognizing the nation by its traditional name, there's no impact on any other existing legislation or clauses in this section, I'm assuming?
Minister?
The member is correct. This amendment does not change the intent of the section.
Shall Clause 45 pass? So ordered. Shall Clause 46 pass? Member?
Thank you. Will the Sea-Shelt Indian government appear anywhere in legislation, or will Sea-Shelt not be written anywhere in legislation relating to the nation moving forward with this clause?
Minister?
Yes, we have amended 6 pieces of legislation to align the new name.
Shall Clause 46 pass? So ordered. Shall Clause 47 pass? Member?
Thank you. So can the minister explain the reasoning behind repealing the definition of proclamation in the Shuswap Nation Government District Enabling Act, and are there any repercussions to this repeal?
Minister?
Thank you, Chair. So the definition of proclamation is repealed, as the term will no longer be required in sections 2 and 5 in the Shuswap Nation Government District Enabling Act. So the amendment does not change the intent of the section.
Member?
Thank you. And so I'm assuming there's no repercussions on the definition of referendum as well?
Minister?
The member is again correct.
Shall Clause 47 pass? So ordered. Shall Clause 48 pass? Member?
Thank you. Can the minister explain the format and election process for the Nation Government District Council, and how is this different from what was in place previously?
Minister?
Thank you, Chair. So the District Council is still the governing body, but we're reflecting Shuswap Nation name in this section.
Member?
Thank you. And in 2, it says the Lieutenant Governor and Council must, by regulation, establish an advisory council to represent all the residents of the Shuswap Nation Government District. Can we get clarification of what exactly that will be creating and for who?
Minister?
Thank you. In that section, the intent is still the same, but just the proclamation is not needed.
Member?
Sorry, the proclamation appears to be in Clause 50. I thought we were on 48. I was more interested in how, basically by order in council, there's going to be an advisory council that must be created and to represent all the residents. So what is meant by all the residents, and how large will this advisory council be?
Minister, would you like to stand?
I was just saying, Chair, that the section that's being amended originally said if a proclamation is issued, the Lieutenant Governor and Council must, by regulation, establish an advisory council to represent all residents of Sechelt Indian Government District. And the new section, it just removes if a proclamation is issued, and the rest of the section is still the same, and that's why the amendment does not change the intent of the section at all.
Member.
And I appreciate, I get where the minister's going, but that, to me, on my copy, looks to be clause 50, and we're on clause 48. And so clause 48 is section 2 is repealed and the following is substituted: status of district council and establishment of advisory council. And that's what the questions are on. So maybe can we have a quick recess so we can compare, make sure we're working from the same. Again, we're not opposed to this. We're just trying to get clarification for things moving forward. So
We'll have a 2-minute recess. Call the committee back to order. There's been an agreement to stand down Clause 48. Shall Clause 49 pass? Member?
Sorry, did you say 49?
Yes.
Yes. So I'm just wondering, when did the federal act get amended to reflect the traditional name?
Minister?
Thank you, Chair. That was in June 23rd, 2022.
Shall Clause 49 pass? So ordered. Shall Clause 50 pass? Member?
Thank you. No, this goes back to a proclamation, but I recognize that some of our confusion came in, so hopefully not again, but I'll give it a shot. Can the minister explain why the proclamation that previously was relevant to the Act has been replaced? What is the significance of removing it? Was it at a request by the nation or that type of process that led us to this point?
Minister.
So in the late 1980s, when the district council was originally recognized, it was done by proclamation. So now this amendment removes that requirement and updates the section. So it repeals the requirement of the district council to be recognized by proclamation and instead provides for the act to enable recognition, which is consistent with the current drafting of statutes. I gotta wait for the people reporting out.
Minister.
Honourable Chair, I move the committee rise and report progress and ask leave to sit again.
Members, you've heard the motion. All those in favor say aye. Opposed say nay. Motion is carried. This committee is adjourned.
Committee Chair.
The Committee on Bill 9 reports progress and asks leave to sit again.
When shall the committee sit again?
Next sitting, Honourable Speaker.
So ordered. Committee Chair.
Mr. Speaker, Committee of Supply, Section A reports resolution and completion of the estimates of Ministry of Forests and reports progress on the Ministry of Emergency Management and Climate Readiness and asks leave to sit again.
When shall the committee sit again?
Next sitting, Honourable Speaker.
So ordered. Committee Chair.
Mr. Speaker, Committee of Supply, Section C reports progress on estimates of the Ministry of Environment Climate Change Strategy and asks leave to sit again.
When shall the committee sit again?
Next sitting, Honourable Speaker.
So ordered. Government House Leader.
Honourable Speaker, I move that when the House next adjourns, it stands adjourned until 10 a.m. on Tuesday, April 2nd, 2024.
Member, you heard the question. All those in favor say aye. Opposed? Motion carried. This House stands adjourned until 10 o'clock Tuesday, April 2nd. Government House Leader. All right. Now you heard the question. All those in favor say aye. Aye. Opposed? Motion carried. This House stands adjourned until 10 o'clock Tuesday, April 2nd.